Welcome everyone. This is Prakash Mahara. I am working at the Asian Human Rights Commission. In order to continue with our interviews with members of the civil society, lawyers, media persons, and human rights advocates, among others, today we have Mr. Prasad Bhusal. Mr. Bhusal is an advocate by profession and has been working as a lawyer in Nepal for the past 18 years. He is a former chairperson at the Collective Campaign for Peace, a national peace building and human rights organization. Currently, he is a secretary member for Justice for Human Rights, a national level network. Prior to taking the responsibility as a chairperson of COCAP, Mr. Bhusal worked at the Advocacy Forum, an established human rights organization in Nepal known for promoting rule of law and taking up sensitive human rights violation cases. Mr. Bhusal has practical experience in publishing critical reviews of existing legal frameworks in Nepal and in making concerted efforts to harmonize them with international human rights standards. Today's interview will focus on policing and custodial torture and death in Nepal. Thank you for joining us, Mr. Bhusal. I would now like to request Mr. Basil to start the interview. Over to you, Mr. Basil. Thank you.
Yeah, welcome. And
thank you very much, Mr. Basil. Thank you very much.
It's very nice to be talking to you, and particularly in these days regarding Nepal. And we have had some earlier discussions, but today the focus we want to have is on custodial death and torture. Maybe you could start and try to give us some overview.
Yeah, thank you very much. Asian Human Rights Commission respected Mr. Basil Fernando and Prakashji and even Shiva Gewaliji. You invited me as interview giver in this topics that we spent our around 20 years lifetime in this sector. It's really like a kind of sharing and kind of like sharing things about in Nepal, custodial death and torture. I have been engaged in earlier time with Advocacy Forum. When I was working with the Advocacy Forum, I had met maybe 2 times with you, Mr. Basil. Last time we met in Dhuli Hill, one conference, 3 days training or conference, something like that over there. And yeah, I believe you are safe. Your health is good, very good.
Thank you.
Yeah, and yeah, lots of information you have. You have very good network with the Nepali Human Rights Agency and organization and civil society member as well. On the basis of those information, you know very well about the current situation and past situation regarding the custodial torture, death, and other human rights violations. And that's why in this, after this, a new government, and there is not so much fundamental changes, to execute it. To execute the constitution and other human rights laws in Nepal. The government approach towards the civil society members and civil society organization is not good. I can say this is comparatively negative. Government approach is not good. And government also like almost bringing new law to control the civil society organization. The bill is pending in parliament. That's why the government approach is not so on favor of the human right and situation of human right. On the basis of that government approach, Nepal police basically, who is directly related with the investigation and torturing, was not like strengthening, was not like harmonized, was not like human rights friendly. And whenever the home minister was appointed, definitely he belongs with Maoist party, who have past rebellion history and who was directly involved in the war or conflict in Nepal. And he is leading the home minister. even the whenever we talk about the prime minister approach also is not, in favor of the rule of law, even the justice. And he is not taking any kind of initiation. He is not giving any kind of order to maintain the, human rights friendly situation in custody in the investigation. That's why whenever we talk about the prime minister, whenever we talk about the Ministry of Home, both of them are not so favorable. They are not in favor of the human right and the rights of the detainees. That's why the approach, entirely approach, is not so good. Whenever we're talking about the National Human Rights Commission, and this government is brought one bill, proposed bill, who is, almost things the Human Rights Commission's rights were, deducted. There was a big discussion about that bill as well. That's why the space of civil society members and organization was shrunken because of the government decision and the approach. That's why even we talk about the Dalit communities, nothing, no any privilege were given to them, nothing reformed on their about their discrimination. Even they were not getting, the rented house properly. They were discriminated everywhere. Even when they've been in government organization or government office, they were discriminated. They were not given any, services properly. That's why even the new laws the government promulgated were heavily criticized because of unfriendly, laws were enacted. They were drafted. Lots of things. Because of the civil society, because of the public, they came to the street. They demonstrate on the street. That's why some bills they are not daring to pass from the parliament. Otherwise, the government entire approach is not so good and not so friendly, not according to our constitution and international other instrument as well.
Now you mentioned that the certain amendments were made regarding the powers of the Human Rights Commission.
Yeah.
Could you kindly explain that a little bit for the outsiders?
Outsider means
people who don't know. Now in your country it may be known.
Yeah.
But the outside they don't know what happened to the commission. What were the limitations?
Yeah. In the history of the National Human Rights Commission, they had recommended. I don't have right now the numbers, how many cases they recommended to execute it to the government. But I know very well, but nothing on the case, on the recommendation of the investigation. Even single case is not actually executed from the government. No single cases. Only some of the cases related with the compensation are like they executed. That's why one thing is that, and because of the recommendation, hundreds of cases were recommended from the National Human Rights Commission, thousands of cases were recommended by the National Human Rights Commission. Those recommendations were somehow, they already registered in international community as well. Like sometimes as a report, sometimes you also receive some things, none applied by the government. Even UN treaty bodies and other kind of like platform of related with UN or OHCHR, they also known very well regarding the approach of the government towards the Human Rights Commission's authority. That's why like that government, he doesn't want to give like independence of the National Human Rights Commission. They were trying to deducted their their money. They are trying to deduct their fund, National Human Rights Commission fund, and they were not interested to I mean to decentralize to the National Human Rights Commission in the provincial level. And if National Human Rights Commission, I mean, recommended to investigate on the cases, and Attorney General have the right whether case will be investigated or not. That kind of like new, the draft they were drafted, and that's why till now National Human Rights Commission is A grade Human Rights Commission in the A grade Human Rights Commission, and whenever they bring new law, National Human Rights Commission will not be the grade one. Even the current National Human Rights Commission, they were appointed on the basis of the political affiliation. I'm not saying about the chairperson of National Human Rights Commission. I'm saying about the other commissioners. They don't have any kind of collaboration. They don't have any kind of collaboration between the members, and they are lobbying to the chairperson on the basis of their affiliation, on the political parties. That's why the Human Rights Commission, from the government side, they are trying to make more, I mean, not so effective Human Rights Commission. And even within the Human Rights Commission's member, they don't have a single, they don't have a one perception, one objectives within those commissioners. That's why that kind of, difficulties they faced. From the outsider, the civil society member, they don't have good collaboration with the civil society member. We've been there a number of times to make their statements, to do some investigation on the cases, sometimes in the extrajudicial killing, sometimes in the custodial death, sometimes in the torture. They have rights, constitutional right, and they have right by their law, but they are not actually, they are not actually doing, using their rights what they have. And this is not actually independent as well. And according to the Vienna Convention, this is not actually independent, the National Human Rights Commission. The independent, somehow they have the constitutional authority and independency. By execution, they are not using their independency properly. And they may have some, political interest as well, because some of members were appointed from one political parties, other members is appointed from another political party. Whenever we talk about current members, their tenure is going to be finished very, very soon, within a month. And some of them were appointed from former UML party. One member is appointed from Nepali Congress. One member is appointed from Maoist parties. That kind of like composition is there. That's why the National Human Rights Commission also not functioning properly. He's not doing, what need to do.
How do you see the situation? Say, let's take the situation of a custodial death.
Okay.
Right.
Okay.
Now, how do you how does it investigated, and how?
Right.
Yeah.
Right. There, we have in last 2 months we have recorded 5 custodial deaths, and 3 of them were from Dalit community. And in Nepal, there is about 69% is cases were succeed in criminal case. The report from the Attorney General, only 69% cases are success case. Within 69%, around 50% cases were related with the petty crime. Petty crime, only for penalty or money, something like that. That's why in Nepal, in criminal justice system, around 35% people who are, actually involved people were investigated. Around 65 innocent people were investigated. 65% people, innocent people, were investigated, and most of them were belongs with the who don't have education, who don't have, I mean, economic background. In custody, in jail, who have good education and who have economic background, good background, they were not investigated and they were not sent to jail. If somehow they were investigated, they will get released from the court in the beginning. That's why the lots of people are being tortured in a custody and being killed in a custody. Most of them belongs with the Dalit community and the marginalized community. They could be from Madhes, they could be from the indigenous community like Tamang, Gurung, something like that. That's why we have new law. The criminal code is inaugurated 2 years before, and there is the provisions. The torture was criminalized in that criminal code, but after that, we also recorded hundreds of cases of the torture. There is no decreased after the inauguration of the new law on the torture. There is no symptoms of the controlling the torture. The situation of torture is still going on. This is I can say this is rampant. This is still systematic in Nepal. Who have the money, who is involved in the case, who have money, when he pay the money to the police, he will not be investigated. He will not getting tortured. Who don't have money, who don't have education, who don't have political nexus or membership, they were not properly. They were being tortured. They were being killed. They don't have good access to the court. They don't have law education. They don't have access to the lawyer even. That's why the situation is still in Nepal. Every day I'm engaging with the detainees every day still, and people are still being tortured more systematically. In current situation, they were not tortured. They were not giving any physical torture. Some of cases were only giving physical torture. Most of the torture were, I could say, like mental torture or psychological torture. They are put in some kind of threat. They were keeping in kind of threat. That kind of system is still going on, because there is one the practices kind of admissibility in the cases. The admissibility of the accused could be the basis of the adjudication to the judge to establish the crime. Admissibility is the base to establish the crime, and only admissibility was taken as a to prove the crime is the main cause of the torture.
Now
the confession, you could say confession, yes.
Now you said that the poor are the people, poor and the uneducated are the people who get most tortured. Now, are they often also the innocent? And is it for the purpose of getting a confession from an innocent person that they often torture, as it has happened in some other countries? Some countries we have come across the situation where the poor and the uneducated are tortured, although they are innocent. They have nothing to do with the crime. But because the police want somebody, and therefore to get a confession, they torture. Does that happen in Nepal?
No. We have one law, the compensation law, torture compensation law, still is existing, and that law was we used in previous days. 2 years before, we used that compensation act, torture compensation act, and that act said that the perpetrator was not liable to pay the compensation. on the basis of that Compensation Act, and the state will pay the compensation if, I mean, the torture established. If court, I mean, give order for the compensation, it was only 1 lakh Nepali rupees, around $1,000, and the compensation was paid by the government, not from the perpetrator. It was the law is still existing, but after the new criminal code on the torture, we use that criminal code, as a crime. We use that criminal code. We are not using that Compensation Act. That's why that compensation also was not, effective to the victims, and the Compensation Act itself is not rely with the international standard. That's why the Compensation Act is a kind of useless to the victim. And after this, criminal code, there is only the provision, the compensation was 50,000. That was not from the that was not from the perpetrator. That was from the state. That's why the compensation and treatment, interim compensation, everything is not there. 50,000 is very small money to the victim. In one case, like in Kanchanpur, in Nirmala Panta case, one innocent person was investigated for 24 days. He was heavily being tortured. The torture waterboarding system was used on him, and court, and 2 months, 2 and something day, 2 months and something day before, the case was, final from the district court. The police officer were get clean sheet, and in Nepal, actually, that kind of practice is not here. Somehow the people who are poor and not educated were they are not arrested by police themselves. Some of victims of the crime, they file the FIR against them. On the basis of FIR, they were arrested, and they were tortured. And being uneducated, being poor people, the police were not arrested and not investigated. On the basis of the FIR of the crime victim, they were arrested first, and after that, whenever they don't have the political access, membership, they don't have money, and they were tortured. They were, sometimes killed. And that kind of situation here in Nepal.
Okay. Now you mentioned about you mentioned about the confessions.
Confession, yeah.
Yeah. In the courts, are the confessions admissible?
Yes. Yes. In the court, first, the basis to the judge and the adjudication process is the confession. First, if he confessed the crime whenever he was in detention, only on that basis and the confession, court can declare them as a criminal. This is the prime evidences to the court. This is the main problem. In Nepal, we have very less practices of the fair trial. There is no, any assurance of the right of the detainees. They don't have, counseling authority, counseling system with the lawyers. The Nepal Constitution, there is provision. Every accused have the right to take the advice from the lawyer from the beginning whenever they arrested. But that right was not, properly used by those detainees. And even they were whenever they were arrested, first they were taken in the different investigation room for the some kind of threat to the torture and the torture, and they have asked the question police asked the question to those people, and they were threatened. The situation, in the beginning, there is really a horrible situation whenever investigation is begin. That's why whenever he admits the crime, there will not will be the torture to the accused person. If he denied crime, and the torture will be started. That's why the admissibility is the main cause in Nepal for the torturing and the killing to the people.
Now, suppose during the trial, the lawyer for the suspect who is being tortured tells the court, well, my client has been tortured. What will the judge do?
In Nepal, like in investigation period, most of the cases investigation period will be for 25 days, and accused 25 days in most of the cases. We have other cases like drugs. In drugs cases, there will be 90 days for the investigation. Police can kept in the custody for 90 days. And organized crime, there is 60 days.
The police in a normal case, they can keep for 25 days.
Yeah.
25 days they can
25
keep
days.
in police custody.
In that custody, with the permission of the court. And at that time, in Nepal, like there is, I could say there is no practices. Even the Nepal Bar Association or lawyers, they are not, interested to visit the accused in the custody because of their prestige will be lost if they've been in custody. That kind of mindset is still here. And we are only the lawyers, some of few lawyers. If we know some people who were arrested in custody, if he called us, he sent us the information or something like that, we frequently met them, and we visit the custody, we met them, we'll provide them our legal advice not to accept in the crime. If you do the crime, you accept, but because of the torture, you do not accept the crime. We will counsel them all of their rights, but there is no practices to visit the accused in a detention. After 25 days, whenever jail bell hearing started, only lawyer will be hired. And that meantime, and he, the accused also, the court also take the statement of the accused in the court. That time, he claimed, most of them, even the 90% accused people were claimed, I have been tortured in a detention. That's why I confessed that crime. Actually, I was not involved in the crime. That kind of, tendency is in, practice in Nepal. Around 90% people, they accept the crime in the detention, in the investigation time. Whenever they send the court, in that statement, 90% people denied their, confession.
So a person who during the investigation admits the crime, when they come to court, they say that I've been tortured, and they deny the crime.
Exactly.
Yeah.
Exactly.
So the question is,
and even the court, I'm just one add, very short things. In a remand period, there is the remand system. In the beginning, there will be first remand, and there could be the second, third remand for the 25 days. The 25 days was not given in single times. First remand, there will be 7 days, sometimes 10 days, sometimes 5 days. Whenever the accused produced before the judge, and if he claimed I have been tortured, the court and judge are not willing to hear that kind of torture. They are not actually interested. They are not interested to give order to stop the torture to him for the treatment and something like that. They are not interested. They are not doing anything. Even though sometimes we filing the application about his torture, to secure his life in a custody, to provide him medical support, because of torture he is facing physical harm and something like that, and court are not accepted that application. Even the court are not giving any kind of order on the torture application. That kind of situation is there.
See, now when the trial starts, the accused says to his lawyer, not the accused, the suspect, he says through his lawyer that he has been tortured, and therefore he wants to withdraw his confession.
Yeah.
What will happen in court?
Yeah, this is actually in general regular lawyer. We are practicing for a long time as a human rights lawyer. We also visited for a long time in a detention. We have very good collaboration. We understood the consequences of torture, the severity of torture. But regular practitioner lawyer, they don't have knowledge. I mean the torture, they don't know. The torture also was regards as a crime. They thinks that torture is the regular things. This is happen. No problem. If you are good right now, you forget about your torture. Most of the practitioner lawyer advised them to the accused like this, but we are not. We are, if we file the case of the medical treatment of the torture, and if court not accepted our application, we'll file against them in the superior court, something like that. Sometimes very few cases we have, whenever the lawyer argue before the judge about his torture and about the confession because of the torture, sometimes the court is giving some good order. I mean, very few bail, sometimes in the ordinary bail, they are giving order. In very few cases, that kind of judges we don't have so much. Very few judges. They also, considered as a torture. This is a regular things. It's happened. The police, yeah, this is good things. If police does not torture, how they confessed, how they accept the crime, that kind of things said by the judges as well. They don't have. They are from the cadre. They were appointed from the staffs, government staffs. They were not civil society member. They are not independent lawyer. District court judges were appointed from the service people, cadre. That's why they have government mindset. They have government mindset. Some of the judges, I found them more rude than the police.
Yeah. See, now in some countries, there is this practice now. Suppose suspect says during the trial, I'm referring to the trial, not the pre-trial,
Yeah.
a trial.
Yeah.
During the trial, if he says, well, I want to withdraw my confession because I was tortured, then the procedure is, before the trial, the judge will have a separate inquiry as to whether he can believe the accused about torture. So at that point, if you have medical evidence and other evidence, you can bring before the judge. And if the judge is satisfied that there had been torture, he will not allow confession to be used. Has anything similar, being adopted in Nepal?
Yeah, I think I also involved one case, that kind of case, like whenever accused produce in a remand time, we, being a lawyer, I also file the application, on his torture to order the further treatment and medical treatment, and his to give order for his further security, and judges gave order for the treatment, in a specific hospital that we demanded, and the document was very good. The teaching hospital forensic department is there. The forensic doctor, Dr. Harihar Wasti is there, and he documented the case. And he sent that document to the court equally. And after that, we filed the case on the torture against the police investigation officer. And on the basis of that documentation, I mean, he got clean sheet because he was confessed in the investigation time. He confessed the crime in the investigation time, and whenever trial period time, in a statement given to the court, he was saying that I was not involved in the crime. And on the basis of the medical document that proved he was being tortured, on the basis of that document, he get clean sheet from the case, and police was, I mean, he was also, suspended. It was not suspended. He was, he was charged for the, torture. Yeah. That time there was not any kind of, punishment. Jail punishment to the police officer. That time, he was just, the courts just say that he was involved in the crime. That's why on the torture case, he was awarded for 50,000 rupees, and that's why he get clean sheet in the final hearing. There is very few cases.
So let's get back to other issues. Can you give some concrete examples of, in the recent times, some custodial killing related cases that you or other lawyers have done, so that we can get a clearer idea of what is going on? Some examples.
Last week I was in Rohtak, province number 2 districts, where one Dalit boy was, actually he was not died in the custody. He was died in the hospital, but he was heavily tortured in the custody. And we've been in same police station. We've been in village where he, stayed, and we documented that case. He was arrested on the murder issue. Another boy was killed by the other people. He was arrested in night time. There was around 150 people, police were deployed in his home area, and every household people were being tortured whenever he was arrested. And he was taken to the custody, and he was compelled to confess the crime. In a night time and daytime, he was continuously tortured in around 3 days. And after he was really injured. He was not good in a detention. That's why he was taken to the hospital. He died in hospital after 7 days. And we have you can find it. Maybe Prakash he also given statement whenever
Dying
treatment
statement.
was going on. Dying statement, dying declaration was there. And whenever we been in a place to file the case against those police officers, and there was very big struggle between the police officer, senior police officer, and in charge of the districts, and victims. Like, we also facilitated to the victims, and they were not agreed to file the cases of FIR in murder and in torture. And after 2-3 days struggle, the police is not ready to file the case. That's why on the basis of our criminal code, we've been in district attorney office, and he registered the case, FIR, and he sent that FIR to the police officer. And we are waiting for the further investigation from the district police. Even in Kathmandu, around 2 months before, there was one custodial death. Most of custodial death were the police said that this is not because of our torture. They were defamed the death, and they were trying to, make the case as a suicidal, not the custodial death. Yeah, 2 months before in Kathmandu Valley, there was one case. He was died within the custody. We've been there in the custody. We met, family member. Even we saw the dead body. Yeah, there was some symptoms of suicidal, but we arguing with the police headquarters and the other officers, because of your negligence, the death was happened. There is series of cases. Most of the cases police were bringing those custodial death on the suicide case as a hanging or something like that. Sometimes they said this is hanging. Sometimes they said that he was a drugs user, that's why he died. That kind of different practices is there. Yeah, we have that kind of experiences in last couple months.
Now, in the criminal procedure code, can you explain what is the change they have made in the on this issue, the criminal procedure code?
Yeah, we have some like new provisions regarding the custodial death. Also, there is some provisions related with the custodial management, and police, they don't have internal any manual regarding the police police accountability towards the investigation and towards the peoples who are in custody. They don't have that provisions and that practice, but we have some provisions in the criminal procedure to look after the detainees, to ensure their security or something like that. There is no so big sentencing management in the place. This is only kind of management. There is no accountability system in a process.
So what is the possibility of some of your lawyers who are knowledgeable about this issue getting together and try to draft the police rules on this, and then presenting it to the to the parliament and to the public as well as to the international community?
Right.
If you spend a little time discussion, you may be able to come out with certain rules regarding arrest. Now, is there a rule that once the person is arrested, he should be told why he is arrested? Do you have that in your law?
Yeah, we have that kind of law. Even the Nepal Constitution said that everybody need in a prior notice. They need to given to prior notice before the arrest. We have that in a previous law as well. In new law, whenever people need to be arrested, police cannot be arrested themselves. In new criminal procedure, and the judge who is responsible for the same case, he need to give his consent for the arrest. Police first, if police receive some complaint from the crime victim, and on the basis of that complaint, police requested to the judge for the arrest to the accused person, and this is the new management in the new procedure, and this is unpracticed right now. But the court, the judge were not so intact on that law management. Whenever police came with the application for the arrest, the judge and court, he doesn't want to ask to the police why he need to be arrested, what is the case, what is the seriousness, is that could be the same people or that could be the other people. That kind of question, no question will be done by the judge. Whenever he received the application for the arrest, police judge will be signed on the letter. That kind of practice is there. And after that, the law said that if somebody need to be arrested and he need to be given that letter first, and you are in this, you have that kind of case against you, we have the arrest letter, you are under arrest. That kind of practice is not there. And police will arrest first that person, and he will bring to the custody, bring to the police station. After that, they will sign on those judge consent to the arrest. The judge consent to the arrest, the letter is not given in the arrest place. All those letters will be given in the police station. They were only for the process, not fulfill for the victims and the accused person. That kind of practice is there, one. And second is like in Nepal police, the Nepal police is accountable towards their department, not towards the court, not towards the attorney general. Attorney general, district attorney general is the equally responsible to look, to monitor the investigation, to give the necessary order, to give the necessary order to the investigation officer, to the police. He have that kind of right still, but this is not, properly practiced. This is not properly practiced. Police is completely accountable towards their department, and in police department, in investigation, department, there is no specific law background police officer. They don't know law. Most of them, around 90 or more than % people, police officer, they are out of the law background. They don't have knowledge or principles of the human right, the rights of the accused person, right and fair trial. They don't know anything. And after that, in their service time, they will get somehow the training or something like that, and on the basis of that training, few police were known about the their rights of the accused. And one thing is that, the another thing is that they were promoted. Police investigation officer were promoted on the basis of the success of the cases. Whenever the court were announced the guilty on the basis of the confession, on the basis of the guilty, the investigation officer will be promoted. He was regarded as the successful officer, not maintaining the human rights things, not maintaining the other things. He will be promoted on the basis of the successful cases, and investigation will be conducted through the torture, and whenever he confessed the crime, he will be guilty from the court, and investigation officer will be promoted on the basis of those successful cases. And that kind of practice we have, and their accountability is not towards the court and not towards the attorney general. Somehow, if the new law, the investigation officer, whenever he promoted, if attorney general or district attorney general can give his marks for their promotion, he will be accountable towards the attorney general or district attorney general. We don't have that kind of practice. That's why the police department still is, they were sometimes transferred in investigation officer, and after 1 year or 2 years, they were transferred from another job, like in peace maintain or something like that, and other job rather than the investigation. There is no specific wings in the investigation. For the only investigation, there is no specific wings. There is some different wings. There is wings like CIB is there, other bureau is there. The bureau is there, but officer could be the different. Sometimes he will be transferred traffic. Sometimes he will be transferred in the other jobs. There is no specific specialization in the investigation. There is no to the police, there is no such kind of encouragement system within the department as well. That's why they were only taking the measure of the torture to be promoted and to be popular within the department and within the society.
What is the liability of a senior police officer who is supervising the junior police officers when it comes to the things like torture and custodial killings?
There is in torture, there is a new criminal code have the management, the superior or in charge of the police station is the responsible for the torture. There is management, but in practice, I already mentioned the Nirmala Panta case, and first case was that, and the torture first case was that after the new torture was criminalized, and that case was failed because of the police, even the police department. I could say police department, the judge and attorney general, where the police force itself is a kind of armed force. They have the guns. They have guns. They are the kind of dress. They have the kind of mindset as a armed, like a kind of armed. They are threatening to the, sometimes they can threat to the judge. Sometimes they can threat to the attorney general, district attorney. Yeah, we have one example. One former police IGP, Inspector General of Police, was involved to abduct the people, abduct the parliamentary. This is very, that kind of criminal mind setup is within the police department and their officer. That's why in the torture case, there is accountability system, there is command responsibility system we have, but there is really difficult to establish the, to file the case, to register the case is really difficult to us. And in that Nirmala Panta case, there was not good investigated the accused person. They were just, they were asked to come to the police station. They were invited to the police station, and they just casually given their statement, not as an accused person, as a police officer. They just give their statement and they were sent back to their home. Whenever a case filed the court, they were again invited and they were given statement before the court. They were not taken in the custody. And they defamed the cases. They were threatened to the victims. They were somehow, they managed the judges. They may buy the judge. We have lots of evidences. Even the government, found some commissions on these cases. Those commissions also stated that that person was being tortured. But in the court, all accused 4 senior police officers were given clean sheet. After that, it was around 2 months and something like more that. After that, there is lots of custodial death and custodial torture we documented. After that, decision. After that decision, that could be that decision. I can say that decision is very harmful decision towards to secure the detainees in the custody. That's why we have legal management to further superior accountability towards the torture and towards the custodial death. But police, he doesn't want to file the case against the senior police officer. In the Rohtak case, Vijayram case, they were really, interested to file the case against the junior police officer, not the in charge of the police station. They are doing bargaining. If you bring FIR for the junior, those people, we are really, happy to file the case. We'll do proper investigation on the case. If you, bring FIR in charge of the station, we can't say. The police officer said that we can't do, proper investigation. That kind of things they have. They are not real. The department is officially in a position to protect the in charge in custodial death, in torture, and other extrajudicial killing wherever it happened.
So among the lawyers, are they getting better in trying to defend the basic human rights of the accused, or they are more with the establishment?
Yeah, after a new government came, in past there was very good civil society, NGOs. There are lots of lawyers like us in past. After this government, there is, very few lawyers. We can count in a finger. We can count, and we are the lawyer. We are continuously working on that kind of cases. We have been facing lots of threats from the police, even the police department, like the senior police officer, very senior police officer. Number of times they threatened to me directly whenever I file the case and the torture in Nirmala Panta case. They said that you are the person who is paralyzing our department. We are not functioning properly because of you. You are our enemy. That kind of threat they give. One my colleagues is faced other case. They were bring one people, and the police bring one people, and that people file the case against my colleagues who is involved in all those cases. And they are trying to threat, sometimes in the verbally they threat, and sometimes they came to my office in COCAP whenever I was in chairperson in COCAP. Number of times from police headquarters, police officer came to my office, and you are not doing good work. You have your family, you have your children. Actually, you are not safe. That kind of threat they give. And other colleagues who are engaging in that kind of cases, they are also facing different kind of threatening. But in Nepal, National Human Rights Commission, they are not in protecting us. And we have Nepal Bar Association. They don't have any mechanisms and any approaches to protect the human rights lawyer and defender and the civil society member. They don't have any mechanisms. Yeah, you are the person, and you are the organization. Sometimes you are giving your urgent appeal to the Nepal government. That definitely, we are taking as a safeguard in that kind of urgent appeal and other things. We have other international organizations and NGOs as well towards our threat. We also sending our threatening report to the embassies in Nepal, like German embassy, like Swiss embassy, and UK embassy. We are sending that information to those embassy people, and sometimes they may talk with the police IGP or Nepal government authority, something like that. We are continuously facing that kind of threats, and we have very few people. If they stop us in Nepal, the case will not be registered before against the police. Few of us, they stop us somehow, and there is no other people who can file the case against the police officer who are involved in crime.
Now, why is that people became there are less lawyers and others who are taking up cases after the new government?
Yeah, very important question, Basil. Like a new government was, the party who is in government is Communist Party, very big party. Currently, we could say the very big party. He have 2/3 majority. Yeah, almost 2/3 majority government, and the opposition party, the party is just only for the name for the opposition, by his role, by his approach towards the human rights, towards the people who don't have access to the service and other things. The opposition is not working properly. He is kind of paralyzed or kind of dead situation. They are struggling within a party. They have lots of disputes within a party. They are engaging in further post and some appointment from the government. They are begging some post from this government. They are engaged on their own job, not towards the civil society member, human rights defender, towards the opposition, also not engaged in towards the government decision against the law and against the rule of law. That's why the situation is that. And other things is that, like the party, the civil society member, most of the civil society member was in past who was really vibrant, who was very active, who have really can pressure to the government. He quietly engaged with the government right now. He is somehow, they most of them were got appointment. Some of them were waiting appointment, and being a member of the party, they are not in a position to argue with the government. To yeah, to they are not in a position to criticize his own government. They are, we can say, they are not actually the civil society member. More than that, they were the party member. That's why the civil society space is empty. No person is there. We are some people, sometimes in a state, sometimes in a district to document the cases, to file the cases. And because there is another problem in Nepal, currently there is another problem because of media. Media also, doing somehow sometimes good things, and kind of police can give money to the media. Police can defend the case through the media. Police is not directly exposing themselves. They are using the media persons. Right now we have lots of YouTubers and lots of online medias, and if they give take some few money, they can divert the issue. Some they can declare somebody is criminal or not. They will declare from their own media. This is kind of media trial, and court and police officer will be feel more pressure because of the media. That kind of situation is there. That's why the justice system, justice mechanism, justice system stakeholder are really, not working properly. They are not in a position actually.
I think we covered quite a lot. Do you want to say something about the trials? Are the trials done in a fair manner?
Yeah. There is kind of, we have new constitution, we have new laws, criminal code and other things. We have lots of international commitment from the government. We have treaties, lots of things we have in a hand. But in practice, about regarding the fair trial, the police department is same. He's not. They are not interested. I could say they are not responsible towards the society and towards the people. They are more responsible towards their own department and themselves. That's why we have really extensive wider things regarding the fair trial. We have very good constitutional mechanism. From the court law, from the Supreme Court judgment, we have very good judgment regarding the fair trial. Even Supreme Court recognized the cases of Miranda. Miranda cases also recognized from the Supreme Court decision. But in a local level and investigation time, we have other things as well. We have the Attorney General. Attorney General is a constitutional body. He have the extensive authority to maintain the custodial things. Attorney General can monitor the custody anytime. He have the constitutional right. And being a lawyer, Attorney General will be always the defense lawyer. Attorney General, his past profession is the defense lawyer. That's why we have very good collaboration. We must have very good collaboration with the Attorney General. We have the very good law, constitutional mechanism. But in practice, Attorney General, I don't found they are properly visited the detention. If some torture victim file any application to the Attorney General, they are not properly investigated on those applications. Main thing is that, like police, I already mentioned lots of things about the police attitude. They are investigated the accused person not as an innocent. They were investigated person as a criminal. We have lots of country have the the principles, the supposed to be innocent. Every accused person supposed to be innocent. That is our principle. But I mean, the police officer, there is attitude, there is practice, there is mindset. There is no any kind of reformation is there. That's why every people who are investigated, somehow they faced the the kind of torture, not being only detention because of the police brutality or the misuse of the war. Because of their attitude, somehow every people will experience their kind of sometimes cruel, sometimes inhumane behavior, and most of times the torture, physically torture or mentally torture. Every people will pass through those behavior from the police whenever the person investigated. That's why there is no, even the court, the judge will not ask anything towards their rights whenever the remand happen. They must ask to the detainees, accused person, you are treated very well, how you are treated from the police, you are provided food or not, you are provided water or not, what is medical facility, do you have access to the lawyer, you need lawyers, do you need lawyers? Judge, nothing asked, nothing ensured from the police, and judge will not be assured on those things. He is not interested to ask any question to the accused person. That's why more than 90% cases, the accused person will confess the crime in investigation, and those people, around 90% people, they denied the case whenever whenever they given a statement in the before the court. That's why, and that actually on the basis of the confession, and court will decide it. Court will be convicted, and we have like experience. Some of people after 12 years, after 10 years, they will get clean sheet from the Supreme Court.
How long usually a trial will take place? How many years?
It was said for 1 year in a trial, but it takes around sometimes 3 years, 4 years, something like that.
Okay, it was a really thank you very much, because it's a very informative discussion. So we will try to in a separate discussions in the future, we will go into more details in various aspects.
Yeah.
So for everybody who participated, please accept our thanks, and it's very instructive, and we will try to give publicity to this interview so that other people can participate.
Yeah, sure.
And we will continue this practice from time to time.
Sure, Basil. Yeah, it's really good time for me as well to share those things. That will be somehow, that benefit will get from Nepali civil society people, human rights defender, and other colleagues like Shivaji and myself. That benefit will be goes towards us to establish the rule of law system in Nepal.
Yeah.
And it is really very big opportunity for me, and good time. After a long time, I met you in this virtual meeting. We are not actually engaging in specific organization. We have a loose network right now. That's why we can send our reports and documentation to Asian Human Rights Commission, to Kazi and you. We will share, and we'll share with you everything what we faced over here. And we also anticipated your expertise and your support towards us, and further decrease the custodial death and torture, and to strengthen the human right and rule of law in Nepal. Basilji.
Thank you. So thank you to everybody. Shivaji, also thank you.
Thank you, sir.
Prakash sir,
Thank you.
thank you very much, Prakash sir. Thank you,
Thank you.
Prakash.
Thank you.
Shiva sir, thank you so much, Shiva sir. Thank you very much.
धन्यवाद
Thank you. Thank you.
Thank you.
Bye.